Good morning, everyone. Welcome to the Medical Board of California Panel A meeting. Today is August 21st, 2024. We're getting started at 9:02. We'll officially call this meeting to order. And this first meeting will be presided over by Judge Van Ruin, who I believe is on the screen somewhere. There he is. Welcome, Judge.
Good morning, Dr. Bolat. Thank you.
All right, I'll turn it over to you.
Do you wish to do your, I know you usually call the quorum beforehand, but although I do that on the record with the petitioners as well, but I'm happy to take over if you want.
Yes, we have a quorum.
Okay, excellent. And right, and is there anyone absent from the list that's on the meeting? Hard for me to see everyone seated there from here, so I couldn't tell for myself. Is anyone absent?
Oh, I'll be doing roll call.
You will? Okay,
Yes.
perfect. Okay, thank you.
Dr. Bolat,
Present.
Dr. Helser,
Here.
Ms. Jung, Ms. Torres, Dr. Tsai, Mr. Watkins. We have a quorum.
All right, and did all of them say yes? Because I couldn't hear all of the responses after. I heard Dr. Bolat and Dr. Heltzer very clearly, but not any of the others.
Dr. Tsai and Mr. Watkins are absent.
Are absent. Thank you so much. I apologize. It's just the audio I couldn't hear. So we've got the quorum. Thank you so much. And I'll have you identify yourself once more when we actually go on the record. But thank you. That way I don't call on board members that aren't there. Thank you. And then let's see, do we have our counsel present? First for Dr. Bagge?
Yes.
Good morning. And who's appearing on behalf of Dr. Bagge?
Morning, Your Honor. Brad Wishick.
Good morning, Mr. Wishick. Sorry, I can't see you so from the image. That's why I can't see who's in the room. Morning.
Morning, Your Honor. John Getchett on behalf of the Attorney General's office. We're just getting set up right now. If you can just give us a second.
I see. No problem. Thank you. Now I can see the back of you, so very good. And Mr. Wishick, your audio sounded very faint to me when you were speaking. Were you just away from the microphone? I just want to make sure I can hear you.
I think it was turned off and Mr. Gatchett gave you the secret handshake and we have it on now.
Fantastic. Thank you so much. Then Mr. Gatchett, just let me know when you all are ready and then we can get started.
Your Honor, we're ready. So when you're ready to proceed.
Perfect. Okay, and before we go on the record, I know there's one legal issue in this case, which is the request for new evidence to be admitted. So what I intend to do with that, I'll call the case and all of that. I'll give all the usual instructions and I'll allow very brief argument from both counsel just to make your record. And then I'll make a ruling on the new evidence and then we'll proceed straight to the oral argument. So just wanted to give you a heads up in terms of that. I have reviewed the briefing. I'll make that clear for the record as well. I just want to give you an opportunity to add anything and then we'll move straight to the regular argument based on that. Any questions, Mr. Wishick?
No.
What about you, Mr. Gatchett?
No, that's fine. It's fine. Thank you.
Very good. Thank you so much. All right. Madam Court Reporter, are you ready for us to go on the record?
Yes, I am.
Thank you. Let's go on the record. All right, we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California. We're here in the matter of the accusation that was filed against Lynn and Bagge, MD, spelled L-Y-N-N and A-N-N, Bagge, B-A-G-G-E, Physicians and Surgeons Certificate number A67930, Medical Board of California case number 800-2020-072-633, and the OAH case number for the oral argument is 2024-070-586. Today is August 21st, 2024. It's approximately 9:07 a.m. This is the date and time set for oral argument in the notice of hearing for oral argument after Superior Court remand. We are conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen, spelled W-I-M space V-A-N space R-O-O-Y-E-N. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument today. First, to ensure that there is a quorum, I would just like to have each of the panel members identify themselves briefly for the record. This is panel A. We can start with you, Dr. Bolat. Thank you.
Yes, Michelle Bolot, present, panel A.
Dr. Helzer.
James Helzer.
Thank you. Ms. Zhang.
Nicole Jung.
Thank you. Good morning, Ms. Zhang. And then Ms. Torres.
Marina Torres.
Good morning, Ms. Torres. Thank you so much. I do find that there is a quorum. And now may I have please the appearances of counsel, first starting with the Deputy Attorney General.
Good morning, Your Honor. John Gatschet, G-A-T-S-C-H-E-T, appearing on behalf of the Medical Board of California and the Attorney General's office.
Good morning, Mr. Gatschet. And then on behalf of the respondent.
Yes, good morning, Your Honor. Brad Wishek, W-I-S-H-E-K, appearing on behalf of Dr. Lynn Bagge.
Good morning, Mr. Wishek. Thank you very much for being here. So for the oral argument, the following process and time limitations will apply. First, the respondent will have 15 minutes for an opening argument. Thereafter, the Deputy Attorney General will have 15 minutes for his opening argument. After respondent will have 5 minutes to present closing argument, and then the Deputy Attorney General also 5 minutes for closing argument. These time limits will be strictly enforced. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel. If the respondent elects to address the panel, I will place the respondent under oath. A court reporter is present to record the proceedings, so I'll just remind everyone to speak clearly and slowly and avoid speaking over each other so that we can have a clear record. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. And again, I'll just remind everyone that the arguments must be based on the existing record and that no new evidence will be heard. And the board has already had the benefit of reading your briefs, but you can certainly emphasize and highlight any matters you wish during your oral argument portion. As I indicated to the parties off the record, before we start the oral argument, I'm aware that there's one legal matter. The respondent has filed a request to present new evidence after the Superior Court remand. Specifically, just so the record's clear, those are proposed exhibits V for Victor through Z for Zelda. First is the declaration of Lynn Bagge, dated July 30th, 2024. That's exhibit V. Next is the declaration of Richard Florio, F-L-O-R-I-O, M.D. This is dated July 29, 2024. That's exhibit W for William. Then there's the declaration of Yvonne Otani, Yvonne spelled Y-V-O-N-N-E, Otani, O-T-A-N-I, M.D. Dated July 19th, 2024, exhibit X. Then there's the declaration of Katie Hodgson, Katie spelled K-A-T-I-E, Hodgson, H-O-D-G-S-O-N, LCSW, dated July 29, 2024, labeled exhibit Y. And then finally, the declaration of Eric Hansen. Eric is E-R-I-C, Hansen, H-A-N-S-E-N, dated July 30th, 2024, marked as exhibit Z. I have reviewed the briefing in support of that, but I want to give the parties an opportunity to respond. So why don't you, since it's your request, Mr. Wishek, you can start again, just brief comments. I don't want to spend a lot of time on it. I have read the briefing, but I want to give you a brief opportunity. So Mr. Wishek, you can go first, then Mr. Gatschet, I'll hear a response from you. Thank you.
Thank you, Your Honor. It's my understanding that Mr. Gatschet does not object to the admission of this new evidence, so I'll let him speak directly to you on that.
Thank you very much. Mr. Gatschet, is that the case?
That is going to be the case. I understand the board usually has a policy not to accept new evidence at these hearings. However, when that has been done, it has been a ground for writ on a Superior Court writ, and it has resulted in remand of decisions back to the board. So I have no objection to exhibits V through Z being accepted into evidence and looked over by the board. I did mention in my briefing exhibit N. I still object to that. I don't believe at this point that respondent is requesting the admission of that document, but for the record, I would just note that I continue to object to that, and that was supported by the Superior Court's decision. Thank you.
Thank you, Mr. Gatchett. And just to clarify, Mr. Wishek, I did not read into your request that you were revisiting Exhibit N. Is that correct?
That's correct. I'm not asking that any evidence that was ruled inadmissible by Judge Larson be admitted at this time.
Thank you very much. All right, so Exhibit N stands as excluded, and then Exhibits V through Z, given the stipulation of the parties, will be admitted for purposes of this oral argument. All right, thank you very much. Then we can move straight to the oral arguments. Again, as I mentioned, you'll go first, Mr. Wishek. You have 15 minutes, and when you're ready, that starts now.
Thank you very much, Your Honor. Good morning. My name is Brad Wishek, and I have the privilege and the honor to represent Dr. Lynn Bagge. As this panel knows, there was a hearing in January of 2023 before a very experienced administrative law judge, Marcy Larson. And over the course of 2 separate days, Judge Larson received numerous exhibits into evidence, which are part of the record before this panel, heard the testimony of Dr. Bagge, an expert, and a number of her colleagues and people who are close to her. And at the conclusion of that hearing, Judge Larson issued a proposed decision that had a number of important factual findings. And one of those factual findings was as to penalty. And what she said in paragraph 54 of the proposed decision with regard to penalty is as follows. Respondent has a 24-year history as a remarkable physician, leader, colleague, and friend. She is adored by her patients. She is admired and respected by her friends and her colleagues. She has lived a life of service and leadership. Respondent made a single isolated mistake that she will not repeat. When all the evidence in the board's disciplinary guidelines are considered, protection of the public does not require that respondent be placed on probation. Respondent does not need monitoring, and no benefit would be gained by requiring respondent to serve a period of probation. Therefore, the most appropriate discipline to be imposed in this case is a public reprimand with a requirement that she complete the 6-month ethics course follow-up and pay the board's cost. As the panel also knows, a slightly differently constituted panel, last November, then issued a decision after a non-adoption that rejected that finding, that factual finding of Judge Larson, and instead issued a decision placing Dr. Bagge on probation, which included a number of substance abusing licensee conditions, including abstaining from alcohol and drugs, testing as required for substance abusing licensees, and a clinical diagnostic evaluation. On behalf of Dr. Bagge, my office filed a petition for a writ of administrative mandamus in the Sacramento County Superior Court, and Judge Rockwell, after hearing the evidence, issued a decision, which is addressed again by the parties in the written briefs, which essentially said the substance abusing licensee conditions and probation were not supported by the findings of this case. And she also said something else very important, which is this. Judge Larson made a factual finding that although we have a presumption that a doctor who is disciplined involving the use of alcohol is a substance abusing licensee, that the evidence in this case rebutted that presumption, a finding that Dr. Bagge is not a substance abusing licensee and that she does not have a substance use disorder. To the extent Judge Rockwell said that she might infer, because these conditions were imposed, that the board, which was silent on that issue, had found her to be a substance abusing licensee, Judge Rockwell said the evidence in this case cannot support such a finding. So we come back before this panel of the board today to determine that same question: what is the appropriate penalty in this case? But there's a very important issue that Judge Rockwell did not address, because she didn't have to get to that, having found the decision to be unsupportive. And that is, can this panel, when it is required by law to give great weight to Judge Larson's factual finding on penalty, can you reject that finding? And that's the question that is before this panel today. Giving great weight to Judge Larson's finding that I just read, can you reject that? Now, my colleague, Mr. Gatchett, has said, yes, you can impose probation in this case, notwithstanding that, if you give it great weight and explain why you're rejecting Judge Larson's decision. And he points to correctly that Judge Rockwell, in her decision, explained there's some evidence in the record here that could support probation. But when this board writes its new decision, in effect, you're not writing on a clean slate. It's not a question of what you, looking at this, say we think is the appropriate penalty, but rather you're reviewing the administrative law judge's decision, and you must afford it great weight. That is that factual finding. And so what does that mean, to give something great weight? What it means is, according to the words of the California Supreme Court, as we explained in our written argument, that where the ALJ's findings are supported by credible, solid evidence, you must adopt them unless there is contrary evidence to the record that you can identify, which is of considerable substantiality. That evidence does not exist in this record. Now, it's been suggested by Mr. Gatchett that you could identify certain factors in this case and then impose probation and monitoring on Dr. Bagge with certain conditions. He suggested perhaps abstention from alcohol, a practice monitor, alcohol education. But what you need to find is that there's a nexus or a connection between something that factually Judge Larson has already found was a one-off, something that she's never going to repeat, for someone that the evidence demonstrates, which is now beyond dispute, does not have a substance use disorder, is not a substance abusing licensee. How would the need to protect public safety be furthered by imposing monitoring, especially involving the use of alcohol, for someone who is not a substance abusing licensee? So I would say to you that under the law, you really, if you follow that law and give great weight to Judge Larson's decision, you really have to adopt her factual finding that a reprimand is adequate to protect the public. But what I also want to say is this: as a lawyer and representing Dr. Bagge, I don't want to stand up here and try to tell the board, you can't do this lawfully. What I'd rather talk about, because I know the members of the board want to protect the public, as is this board's obligation, and they want to be right and do fair by Dr. Bagge. So what I want to talk about for a moment is why you should adopt that decision, not because the law says you have to give great weight to it, although I think that's true. I want to talk about why you should agree and find that that was the right decision. Now, our judge just explained, and counsel, Mr. Gatchett, has agreed that you could receive 5 new declarations that were submitted on Dr. Bagge's behalf. And the purpose of that is that this hearing has now been held. It's almost 4 years since the time that Dr. Bagge was arrested and made this mistake. It's been more than a year and a half, about 19 months since Judge Larson heard this evidence and made this finding. So what you need to know is what's been happening in the interim. And what's been happening in the interim, these declarations established beyond dispute, is that Judge Larson got it right. This doctor has been faced with some of the most extraordinary challenges that any person could face in their life over the course of the last 18 months. And yet during that time, she has continued to perform as a leader at the Kaiser Permanente Group to the highest levels. She has continued in her professional practice as a clinician to provide the best care, and her patients say that that's so from her patient satisfaction surveys. She has continued to see her LCSW, who she began seeing in 2019, to ensure that she remained healthy and able to provide the best care to her patients and the best leadership, long before this event occurred that brings us here. And at no time during that period of time has she ever turned to the use of alcohol to deal with these challenges. I'm going to begin with just an excerpt from Exhibit Y, which is the letter from her therapist, Katie Hodgson. This is what she says about the past year and a half since Judge Larson's decision. In the last 18 months, Lynn has come to therapy seeking support around the following issues: the ongoing emotional impact of the DUI, her diagnosis with and treatment of breast cancer, complicated care coordination for her aging father, her long-term partner's acute health crisis and ongoing treatment, and her transition into the late phase of her medical career. This has been an incredibly heavy load to carry, but Lynn shows up for therapy with hope, humility, and a willingness to work. I have encouraged Lynn to ask for support and build upon the close relationships in her life during this very challenging time. Lynn has successfully navigated recent life challenges without even considering the use of alcohol to numb or distract from her feelings. She has internalized the DUI as a constant reminder of what happens when we as humans look to the wrong places for comfort. In my experience, patients who are not ready to make the lasting changes that lead to safe choices around alcohol are not shaken by their mistakes. Lynn was shaken to the core and has worked incredibly hard to regain self-respect and trust her own decision. She does not fail to reflect upon her mistakes, take accountability, and choose wisely. Her declaration concludes with her observing that she has no concerns, notwithstanding her extensive experience with substance use, that Lynn would use alcohol in any way that would endanger others or her patients, and that she sees no need for restrictions upon Lynn's practice as she returns to work after her treatment. Eric Hansen wrote the declaration within Exhibit Z, and this is the life partner of Dr. Bagge, with a long-term relationship, who knows her as well as anyone. And this is what he says in part: in our private life, there is not a day that goes by that Lynn does not share with me the joys, sorrows, humor, and complexities of patient care, along with the triumphs, both big and small, with her extensive administrative duties. She is a unique and wonderful person, and an excellent doctor who made a one-off mistake that put others at risk. It would be difficult to describe how this single act has hung over her for the last 3.5 years. As an honest, self-aware, and deeply responsible person, it troubles her profoundly. Out of respect for the ongoing concerns of the medical board, Lynn stopped drinking any alcohol in December of 2023. That includes cooking with wine or taking any medications or foods that contain alcohol. She has learned hard lessons from this mistake, is deeply remorseful and ashamed of her behavior, and wants nothing more than to put all of this behind her. I'm not going to read from it, but you have a declaration from her immediate supervisor, Dr. Richard Florio. And what he confirms is he knows, as Dr. Bagge's supervisor, all of the challenges that are recounted in her therapist letter, and has watched her firsthand. And what he confirms as her direct supervisor is she continues to be an exceptional leader of other physicians at TPMG. She continues to have the highest patient satisfaction scores, 95 percentile, from her patients and her patients' parents, and that she has shared with him that she made a decision after reading Panel A's decision last November to stop drinking alcohol, and has seen her in social situations where alcohol is present, but he knows that Lynn does not drink alcohol. Finally, I want to conclude with Exhibit X. This is an extraordinary letter written by a very close personal friend who knows Lynn as well as anybody. That's Dr. Yvonne O'Connor. She, like Dr. Bagge's supervisor, talks about the challenges that Dr. Bagge has faced, how she shared with her that she has stopped drinking alcohol because she took to heart what the board said in its earlier decision, and how she continues to excel as a leader and as a physician providing the best clinical care.
1 minute remaining.
Thank you. She concludes with this. I know Lynn appreciates the seriousness of her mistake in this case. Every time in the last few years that we have seen each other, and they meet approximately monthly, we have discussed her case. Each time she is brought to tears, and me as well. As her close friend, I can attest to the anxiety and the sadness Lynn has over this case for these last years. We have never had a dinner where she does not express regret concerning her initial mistake. The profound impact of her arrest, conviction, and proceedings is such that there is no question that Lynn would never again use alcohol in a manner which endangered any. Very shortly, you're going to have an opportunity to hear from Dr. Bagge. And I believe you will be convinced that this is a person who does not need any monitoring or conditions of probation, because she will continue to succeed as she has. I urge you to adopt the factual finding regarding penalty by Judge Larson. Thank you.
Thank you very much, Mr. Wishek. Mr. Gatchett, if you're ready to proceed, your 15 minutes starts now. Thank you.
Thank you, Your Honor. So my goal here today is to kind of explain to you on remand the options the board has. And so I think that's important that you have an idea of what you can do and potentially what might not be advisable. First, on remand, I do know that the board typically has a policy not to review new evidence. You'll notice I did not object to the introduction of new evidence. The evidence that is being requested is mitigation evidence that occurred after the hearing during the intervening time. I recommend to the board that you do review that evidence, give it whatever weight you believe is important. Under 1094.5, the Code of Civil Procedure, a reviewing court could take up that evidence. And so if you reject that evidence, you run the risk of potentially having another writ in this case. Writ means longer period of time, we come back here before you. Goal today is to end this case with no writ coming out of this case, or at least not having another one of these hearings. So that's my first part on the new evidence. This case has been going on for a long time. When the board issued its decision rejecting the ALJ's proposed decision, the board imposed substance abusing licensee terms and imposed terms that were not part of the substance abusing licensee terms. As I detailed in my briefing, in looking at the court's ruling, I think it is very clear that the Superior Court is telegraphing that even if the board wants to impose substance abusing terms in this case, even if the board felt, well, I don't think that Dr. Sandor is credible, I think the Superior Court is telegraphing to the board, and it will be the same judge who hears this case when it's returned, that she has made a determination that there is no evidence in this record to rebut or to stop the rebuttal of the presumption that the respondent was not a substance abusing licensee. And by the way, this is when you're getting into double negatives. So if at some point I become unclear, please let me know. So I would, while the board would have the option to take that finding of the ALJ and give it great weight and find that no, we still believe that Dr. Sandor was not credible. And I cite in my briefing to the record where I argued Dr. Sandor wasn't credible. That said, even if the board wanted to take that, I do believe on further writ that the Superior Court would still probably find against the board and we'd be back here again. The Superior Court's decision was a bit of a split verdict or split judgment. The court decided that no, the decision was not protected or not supported by discretion, or the board's discretion was not clearly set forth with the factual findings, and that's why we're back here. The board did reject two of the respondents' requests. One, that by law, a public reprimand be imposed, finding that the board still retains the discretion to impose a probationary imposition in this case. Now, also rejecting the Exhibit N, which, as you noted earlier, I continue to object to. And counsel's not asking for that to be taken into account. So, leaving the substance abuse licensee probation terms, so those guidelines, and there are two sets of disciplinary guidelines we're looking at today, okay? There's the substance abusing guidelines, which I think we can safely, I recommend getting out of those and allowing for that finding by the ALJ that she rebutted that presumption. And then you have a second set of guidelines, the normal disciplinary guidelines for all cases. And that's where the Superior Court said there is evidence in this record to support the imposition of probation. And so the Superior Court rejected imposing a public reprimand. In my briefing, I have cited to the record the facts that I believe, that we believe indicate that probation is appropriate, a probation that does not have use of the substance abusing licensee terms. In order for the board to get to that, the board is going to have to give great weight to the finding of the ALJ. So we have an interplay here between two statutes, and this is, bad news from lawyers. This is an uncertain area of the law. 2335 has not been defined by a Superior Court. It has not been defined by an appellate court. It has not been defined by the Supreme Court of California. We can look by analogy to great weight in other statutes. Counsel cited a case of the Compensation Workers Board, Lamb from the California Supreme Court from 1974. We cite a case from the Youth Authority from 2002 from a lower appellate court. Both of those statutes are looking at great weight in contexts that are not the context before here. I would say, looking at Lamb, it is distinguishable. In that case, an ALJ made a finding that the respondent had, or the petitioner or plaintiff had suffered great stress. The board said, no, I don't think you can say great stress. That's in the eye of the beholder, rejected that. And on appeal, the Supreme Court noted there was just no evidence in the record that the board had presented that indicated the petitioner had actually not suffered from great stress. So you had a situation where great stress was alleged and no evidence against it. That is different than in this case in terms of penalty. If this board decides to reject the ALJ's finding that a public reprimand was appropriate and give that finding great weight, but reject it, there is evidence in this record, as I noted to the board, that would indicate probation is appropriate. And there is a long history of case law in California that, although 2335 says you must give great weight to an ALJ's decision, there is a long set of case law in California that says the board is vested with final discretion on giving penalty. One of the problems with the board's initial decision in this case that the Superior Court judge pointed out, and probably what created a lot of this, is the board deleted findings from the ALJ. I do not recommend you delete findings in the ALJ's proposed decision. Unfortunately, those findings have been made, and 2335 is going to ensure that those findings have to be part of any decision that you issue. What I would recommend is, instead of deleting those findings without explanation, and you can read the Superior Court's decision, have those findings in your decision, give those findings the great weight they deserve pursuant to statute under 2335, explain why you're rejecting those findings, including the finding for penalty, citing to the record, for example, the areas that I've cited in my brief, and that will allow this board, if this board so chooses, to impose probation in this case. And that would be probation under the normal guidelines for a violation of 2239 and a violation of 2236. Conviction of a crime, in this case, was the original impetus for pushing this case as an accusation, and use of alcohol in a dangerous manner, unsafe to the public. The board can go through those facts. They're set forth in the briefing. I know some of you are newer board members, and so we're not here for the first hearing on this case. So you may need to reacquaint yourself with some of the facts. I would briefly just state how this case came about is respondent got off work, she got home, and she made herself a number of gin and tonics. She drank the gin and tonics in about an hour. Her boyfriend was supposed to come over. He was unable to make it to her house, and she made the very regrettable decision of getting behind the wheel of a vehicle and driving from her house in East Sacramento to Land Park. And about halfway there, did not stop, rear-ended another vehicle. Thankfully, there was no injuries to any party, and the damage was de minimis in terms of like bumper scratches. But still, she hit another vehicle, and the other driver, when she approached the other driver, realized she was under the influence of alcohol, and she had a 0.2. The biggest parts of this case that I look when we look at this, the facts of why probation may be appropriate, is she lied to law enforcement. And in fact, not only did she lie to law enforcement, she doubled down. When law enforcement asked her, "Have you been drinking?" she said, "One." And they asked, "Well, what have you been drinking?" She said, "Oh, I've been drinking wine." And then Sauvignon Blanc. She actually named a varietal, which was well beyond what was actually at work here. She'd had 3 gin and tonics and then decided to drive. So those are the facts of the case. And that is the path this board has in order to impose probation if this board so chooses. Conversely, this board may find, after reviewing the record in this case and looking at the new evidence, that the board gives great weight to the ALJ's findings and decides not to overturn them, and may impose what was the recommended penalty from the ALJ now almost a year and a half ago, of a public reprimand with costs and the ethics course. That is all within the power of the board. So I would note that a public reprimand is not in line with the disciplinary guidelines in this case. That's the board's disciplinary guidelines that it goes through the regulatory process to impose. It would represent a significant downward departure from those disciplinary guidelines. The minimum disciplinary guidelines for a violation of 2236 and 2239, even if we're outside of the substance abuse licensee context, those guidelines still, the minimum term is probation in this case. And so the board's own disciplinary guidelines would impose probation. The ALJ clearly did not follow the guidelines in that respect, and made a downward departure. This board may determine that that is an unwarranted departure based on the facts in the record. But in order to do so, as I reiterate again, this board must give those findings great weight of the ALJ and then explain why why the facts in the record are such that those great weight findings should be rejected. And with that, I think I've covered everything that I wanted to cover with the board. I'm here to answer any questions that the board may have about this case and any of the cases cited in our briefing. And I thank you very much for the opportunity to speak to you.
Thank you very much, Mr. Gatchett. All right, Mr. Wishick, you can have 5 minutes for your reply argument if you wish, and that time starts now.
Thank you. I don't want to belabor it, but I do have to take issue with Mr. Gatchett's characterization of the Lamb case that explains great weight. I think the case is very close to what we have here, in that, as he explained, there was an administrative law judge in a workers' compensation case that made findings, and then the board actually was faced with testimony from 4 physicians. So I have to disagree with Mr. Gatchett when he says there was no evidence that supported the idea that this particular individual had not suffered stress in connection with his job. To the contrary, the administrative law judge had the opportunity to see and observe each of 4 experts who testified. 2 experts testified that he was not entitled essentially to compensation because his job didn't have any relationship to the injury that led to his death. But the other 2 doctors testified that just to the contrary. The administrative law judge had the opportunity to see, hear, judge the demeanor of these experts, and concluded to reject the testimony that was contrary to their finding, and made a factual finding relying upon 2 of these 4 competing doctors. When it got to the board, they did just the opposite. without seeing or hearing from the witnesses, they accepted what the other two doctors had said. The California Supreme Court said great weight means that that judge who heard and saw the evidence had made this finding, if it's solid and based on credible evidence, which it was from these two doctors, you can't then substitute your judgment and accept what two different doctors said. There was a conflict in the evidence. What's different here is there isn't a conflict in the evidence. It's really the case that Mr. Gatchett was talking about. The fact of the matter is that we have a factual finding that makes sense. And the factual finding is this doctor made a human one-time mistake. She's accepted responsibility and moved forward from that in every way that a person could do to atone for that mistake. And now with the passage of time, the proof is in the pudding, as we say. Judge Larson said, this is never going to happen again. We don't need to have this doctor on monitoring. It's not going to enhance public safety. And you can see that's exactly right. So the question isn't, is there in some universe some evidence in this record, which is what Judge Rockwell said, that supports probation? That means if Judge Larson said this is a probation case, I think we need monitoring, and the board adopted that, then she's not going to set that decision aside. But in this case, she made the opposite finding. And the last thing I want to say about this is an extraordinary situation. The other licensing boards of this state, if they reject the decision, you start over. You use your judgment as the experts as to what's appropriate with both physicians and lay people on this board. But the podiatric board and the medical board have panels that the legislature has set up. Judges like our judge here today go through training that is recommended by this board to ensure that these judges have extra expertise in making these decisions and evaluating the evidence and expert evidence. And that's the reason, obviously, why this and the podiatric board are the only boards that I'm aware of who are required to give great weight by statutory command to what the judge who heard the evidence says. But most important is the last 19 months. You can see that this is someone who thinks about this case every day, cries tears with her friend every month over it. She is never going to make this mistake again. And public safety does not require that Dr. Bagge have monitoring or testing or anything else that we would normally associate with substance abusing licensees. Thank you.
Thank you, Mr. Wishek. Mr. Gatchett, you have another 5 minutes for reply argument as well, and that starts now.
I would just point the board. I know, and counsel and I have been, legally battling on this case for a long time, but I think, that's part of our nature. I would point that the Superior Court, in its judgment, it is pretty clear that she did not make a finding that a public reprimand is the only appropriate penalty in this case. I would direct the board to page 9 of 10 of her order, and I would read to you, it is undisputed that the petitioner was convicted of a DUI. Evidence in the record shows the petitioner chose to drive after consuming multiple alcoholic drinks and that the petitioner had a BAC of 0.184 after her arrest. The medical board's duty is to protect the public when disciplining a licensee. She cited FAMI versus Medical Board and Bryce versus Board of Medical Quality Assurance, both cases I cited in our briefing. And this is what she noted. Although the evidence also indicates that this is an incident was a mistake and will not be repeated by petitioner, there is evidence in the record that supports an order of probation. The court cannot find as a matter of law that no evidence exists to support the medical board's order. So I would note to the board members, you do have the power to impose probation in this case. I do not recommend you impose substance abusing terms from the Uniform Substance Abusing Licensee guidelines. I do believe that would be not advisable. However, under the normal guidelines, which the respondent concedes apply to this case, and the Superior Court conceded there is evidence in this record, it's just if the board wishes to do so, the board must follow the statutory dictates of Business Professions Code 2335. You must give the ALJ's findings great weight and explain why you're rejecting them. And with that, I'll submit on our arguments.
Thank you very much, Mr. Gatchett. All right, Mr. Wishick, would your client like the opportunity to address the board?
She would. Thank you, Your Honor.
Thank you very much. Dr. Bagge, good morning. Thank you very much for being here. The first thing I'm going to have you do is raise your right hand and I'll swear you in. Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Dr. Bagge. And with that, I'll turn it over to you. You're welcome to address the board as you deem appropriate. And then after that, board members may have questions for you and or the attorneys in the case. Thank you, Dr. Bagge. Go ahead.
Thank you. Good morning, and thank you for taking the additional time to review the facts of my case today. For nearly 4 years now, I have agonized over my mistake, and I hope it's clear that I am deeply sorry, take full responsibility for my bad behavior, and that there's zero risk that this will ever happen again. I'm able to navigate my life's challenges with strength, humility, and grace, and I do not turn to alcohol to cope. I want to share a little bit more about who I am and the different roles I play in my life. I'm a senior physician leader at Kaiser Permanente, and as assistant physician-in-chief, I supervise the departments of adult and family medicine, mental health and wellness, chronic conditions management, health education, and the outpatient pharmacy. In my role, I lead over 400 physicians and 600 staff members to continuously improve in the quality of care and service that we provide to all of our patients across the entire North Valley. I lead the organization despite a critical shortage of physicians, primary care doctors, mental health professionals, and an ever-growing population of aging patients who are living with complex chronic diseases. It's a difficult time to be a doctor when our nation's healthcare is in crisis, and it's a challenging time to be a leader in a large organization. In my 24 years as a general pediatrician, I've always worked to be a role model for my junior colleagues. Over the years, I've taken care of thousands of children and their children and their children's children. And it is, in fact, a marathon and not a sprint. I pour my heart and soul into my practice, relying on my stamina and my commitment to service. It's extremely rewarding, and I believe there's no higher calling than caring for children. I'm a daughter, and in the past several months, I've taken on the complicated care of my elderly father who has Parkinson's disease. Today, he's stable and safe in his own home, hundreds of miles away in Los Angeles, because I am able to diligently care for his finances, his complete medical care, and help manage his team of in-home healthcare providers. I'm a partner. Last fall, the love of my life suffered a massive DVT and a saddle pulmonary embolism and nearly died. Now we live with the realities of getting older, and we have different priorities. We are grateful for our health, and we pursue wellness on a daily basis. I'm also a cancer patient. In February, my annual screening mammogram detected an abnormality, and I was diagnosed with infiltrating ductal carcinoma. When 1 in 8 women are diagnosed with breast cancer, nearly all of us know someone who proudly wears that pink ribbon. One of those women was my beloved mother, who had breast cancer twice and died not that long ago. She was my role model, and I admired her courage during her complicated and long treatment history. And my journey so far has included 2 surgeries, a course of radiation therapy, and now oral medications. Thankfully, I'm getting my energy back and I'm cancer-free. In each of these roles, I accepted a difficult situation and turned it into a positive learning experience. With my DUI, I accepted responsibility, took care of my punishment and requirements, and then tried to move on. After our last meeting, I learned that the board had serious concerns about my rare use of alcohol, and so I decided to abstain completely. Alcohol plays no role in my life. I take all of my roles very seriously. I take my job very seriously. In general, pediatrics is a happy job. The babies are cute, and the kids are silly, and the teens are sweet, and everyone's pretty healthy. And often I jokingly refer to my job as being an expert in boogers and boo-boos. All jokes aside, though, what we do as general pediatricians is very serious. We must keep our children safe from serious disease and injury. And it's a very serious calling. Recently, a colleague asked me, in fact, to see one of her patients who was coming in for an injury. She was on her way out the door and she said, "Hey, can you cover for me? Look in on this kid and make sure everything's okay." And I thought, well, sure, except X-ray is closing, but that's okay. Let me see what needs to happen. And when I walked in the room, I found a mother and not one, but 3 children. They had just fled from their family home because the father was raging around the house with a knife in his hand, threatening to punish anyone who opposed him. And so there is this poor woman clutching a grocery bag full of clothes and her 3 children crawling around the exam room. And she says to me, "Dr. Bagge, what do we do? I don't know what to do." Fortunately, I do know what to do. I know exactly what to do because that's what we do to take care of children and families and to keep them safe. So I scrambled around and grabbed some crayons and some graham crackers and all the forms and all the phone numbers. And we made a plan. I examined all the children very carefully, documented all of my findings, and we decided what would need to happen next to keep them safe. You know, some evenings I'm staying late at the office because I'm comforting a distraught new mother who's exhausted and trying to breastfeed her newborn. And some evenings I'm staying late for a case like the one I just described, which is a lot more serious, but both of them equally important. I love my job and I love to be there for my patients. And no matter what the reason, it's the right thing to do. So I'm here to also answer any questions that you might have about me or my case, or hear about what additional worries or concerns you have. Thank you.
Thank you very much, Dr. Bagge. All right, now I'm going to have the board members ask any questions they would like. I'm going to start with you, Dr. Bolad, and each of the board members, you can pose questions to Dr. Bagge, or if you have any questions for council, you're welcome. Just make sure you indicate who you're addressing your question to. Dr. Bolad, do you have any questions?
Yes, thank you, Your Honor. Thank you for the deliberations. Appreciated the breakdown of the great weight versus the probation. That specifically 2239 and 2236, I think, as you cited. And I really appreciated your presentation, Dr. Bagge. And I would ask, I think, our council just to break down what the probationary, and I understand how we do get the great weight, but what would that consist of based upon our guidelines?
Right. So your guidelines are pretty clear and set forth, and I know Ms. Webb can help you with that as well as staff counsel. They're in the record and they've been admitted, and so I don't have the guidelines in front of me right here, but the board has a wide range of options under a probation. The board could impose the recommended minimum term, which is 5 years. The board could go below that, impose a 3-year term. The board can impose a 2-year term, recognizing that The respondent has been pending this litigation now for a number of years without any new criminal law violations, but while still imposing probation of some sort. Terms that the board can impose are set forth. There was one term that was already taken care of but could be imposed, which is an ethics course. But the general terms of probation include quarterly reports to a probation monitor. I don't think a practice monitor would necessarily be needed in a case like this, but there are terms, even outside of the substance abusing terms, like abstain from alcohol, abstain from drugs, a modified alcohol testing term, which, while the substance abusing term and the uniform guidelines requires I think it's about 130 tests a year, the disciplinary guidelines have a substance testing term that is significantly less. And so this board could make a determination of somewhere, and even moving inside the guidelines, 12 tests over the next year to enforce an abstain from alcohol term. Other terms that could be included in that would be the general terms and conditions. Costs were initially ordered. The board could continue to order costs. I believe it's in the record, but I believe it was $13,000. Anyway, you'd have to go look. Don't quote me on that. But so that would be a term and condition. And then the normal probation monitoring terms, the out of compliance terms, out of practice terms, those are all listed in the general terms and conditions of probation. So those are all terms that this board could impose. It has now been since November of 2020 when this incident occurred. The board has never imposed probation on the respondent's license because we have been going through litigation. And so that is just kind of a reality. And so we are pushing now 3 years since this incident occurred, but the board still has jurisdiction in this case. That's why the accusation was filed. We went to hearing, and there are a number of things that are not disputed in this case. Respondent agrees the disciplinary guidelines applies, and the respondent agrees that there is a basis to impose discipline. The respondent is making the argument that discipline is appropriate, is a public reprimand as recommended by the ALJ. We are not recommending that. We're recommending that the board follow its guidelines, but the board has wide discretion within its guidelines to impose penalty. So I hope that answers your question.
Thank you very.
Did you have any other questions, Dr. Bola?
Thank you very much.
Thank you so much. Let's turn to you, Dr. Health. Are there any questions for any of the parties?
I don't have any questions. Thank you, Your Honor.
Thank you, Dr. Heltzer. Ms. Jong, any questions?
No questions. Thank you.
Thank you. And how about you, Ms. Torres?
Just one question for government counsel. Not that I'm leaning any one way or the other, I'm just genuinely curious. Would it be possible to apply a certain term of probation retroactively and consider it, for example, as already served, just given the amount of time that's already been passed?
I would not recommend doing a term of probation and giving retroactive credit. If the board is looking at giving a shorter term of probation, recognizing, like I said, the minimum term of probation, the guidelines is 5 years. So, the board could recognize, hey, it's been 2 or 3 years, there's been no issues. We're going to give her credit for 2 or 3 years and impose, let's say, an 18-month term of probation or a 2-year probation, but still impose a term of probation, thus putting the license under some rehabilitative efforts, including some monitoring, ensure that, she stated she's no longer using alcohol. Well, great. The board doesn't actually have a test that indicates that a short term of probation would allow for, some monitoring over the next 1.5 years or 2 years. If that was what the board did, that would kind of, I think, reach what the board member is potentially suggesting. But I would not recommend imposing, for example, a 3-year term of probation and giving her credit for 3 years of probation. She has not been monitored at any point over the last, at least by the board. She did have criminal probation. It was informal probation. Once the informal probation was done, she sought 1203.4 relief, and the criminal case was dismissed. So, but DUI informal probation is not quite the same level of monitoring that the board imposes when it imposes probation.
Thank you.
Did any other board member have a question? All right. Thank you very much. Council, thank you very much for your presentations. That concludes the arguments in this matter. The record is closed. Case is submitted for decision, and we are off the record in this matter. The panel will be deliberating in a closed session later. Thank you. Dr. Bolat, I'll turn it over to you as to how you wish to proceed. I'm ready to proceed with the next petition whenever you are.
All right. Would you like to take, if anyone wants to take a 5? Is that okay? 5 minutes, Your Honor, get people's time to set up.
Absolutely. Sounds great. So I'll come back around 10:07, looks like.
Thank you.
587. Today is August 21st, 2024. It's now approximately 10:10 a.m. This is the date and time set for oral argument in the notice of hearing for oral argument after non-adoption of a proposed decision. We are conducting the oral argument in person and by WebEx video conference. My name is Wim van Rooyen, spelled W-I-M space V-A-N space R-O-O-Y-E-N. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument. First, to ensure that we have a quorum, can I please have each member of the panel identify themselves for the record, starting with you, Dr. Bolat. Thank you.
Yes, Michelle Bolat, present.
James Helzer, present.
Marina Torres, present.
Feeling Sai, present.
Nicole Jung, present.
Thank you very much. I do find that we have a quorum for purposes of the oral argument. And now may I please have appearances of counsel, starting with the Attorney General.
Greg Chambers, Supervising Deputy Attorney General, State of California.
Good morning, Mr. Chambers. And then on behalf of the respondent or the petitioner in this matter.
Good morning, Your Honor. Good morning, panel members. Nicholas Jerkowitz on behalf of Dr. Cronin, who is also present.
Thank you. Good morning to both you, Mr. Jerkowitz, as well as your client, Dr. Cronin. So for the oral argument, the following process and time limitations will apply. First, the respondent will have 15 minutes to present an opening argument. After that, the Deputy Attorney General will also have 15 minutes for his opening argument. Thereafter, respondent will have 5 minutes for a closing argument, and then the Deputy Attorney General will also have 5 minutes for a closing argument. These time limits will be strictly enforced. I'll put it on counsel to monitor your own time, although I'll try to give you a courtesy 1-minute warning. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. Panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer the respondent physician an opportunity to address the panel. If the respondent elects to address the panel, I will place the respondent under oath. A court reporter is present to record the proceedings. For purposes of creating an accurate record, please make sure to speak loudly and clearly, slowly, and also try and avoid speaking over another person. After the oral argument, the board will go into a closed session to deliberate. The parties will not receive a decision today, but will be receiving it in the mail sometime in the future. Again, I'll just remind everyone that all arguments must be based on the existing record and that no new evidence will be heard. The board has already had the benefit of reading your briefs, but you're certainly welcome to emphasize any portions or issues you feel are particularly pertinent. And with that, we will start the oral argument. And first up is the respondent, Mr. Jerkowitz. You have 15 minutes, and that time starts now.
Thank you, Your Honor. And I don't think initially I'll be taking that much time. I think that this is a relatively straightforward, simple case, and I want to leave some time for Dr. Cronin to address the panel. As the panel knows, these medical board proceedings are not about punishment. It's about protecting the public. Based upon the record in this case, and it's a long case that goes back years between the first case and this case, there is no evidence at all to support a finding that Dr. Cronin poses a danger to the public if he is granted a full, unrestricted license. The complainant's brief filed in this case does not cite to any evidence or testimony to support its contention that Dr. Cronin continues to pose a safety risk. On the contrary, the evidence in this matter is overwhelming in supporting that Dr. Cronin is deserving of an unrestricted license. The evidence is also overwhelming that Dr. Cronin is rehabilitated. The record shows that Dr. Cronin engaged in multiple treatment programs, ongoing monitoring for nearly 10 plus years. His professional monitors testified and provided statements that he is safe to have an unrestricted license. He's engaged in numerous 12-step programs. He's shown tremendous remorse, introspection, and self-growth. Over 10 plus years ago, Dr. Cronin did not have a strong support system to deal with his life's pressures. The evidence shows that today he has a strong support system and has learned to deal with life's stressors from all his hard work. It is beyond question, and the evidence is overwhelming in this case, that Dr. Cronin is a different person today than he was 10 plus years ago. This is a patient at issue here, where Dr. Cronin treated this patient beginning in 2008 and stopped treating this patient in 2014. He admitted to engaging in an inappropriate relationship with the patient for about a year between 2013 and 2014. So we're talking about a single isolated event in a long career for Dr. Cronin that is over 10 years old. And during this 10-year period, he has done everything. I want to repeat that. He has done everything a human being can do to show rehabilitation, remorse, and to move on with his life. I'm not going to summarize each and everything Dr. Cronin has done because it's in the record, but it is quite extensive. And I would be happy to address any thoughts that there's more he could do, because there really truly is nothing more he could do. He's done not just one 12-step program, multiple different 12-step programs. He's engaged in multiple treatment center visits or enrollment. He has developed new strategies to cope with life. He's done a lot of therapy. He's improved his relationships with his family. He's tremendously improved his relationship with his wife. Not only that, but he's been on probation now for 4 years. And during that time, he's been a model citizen. He's been perfect in his probation. And again, other than this one incident, he has no history of any discipline by any board, nor does he have any history of malpractice or anything like that. I want to address, I think, really the singular issue in this case, which is, should Dr. Cronin be, his probation terminated, and should he be granted an unrestricted license? And again, as I said before, the purpose of these proceedings is not to punish Dr. Cronin. It's to protect the public. And other than the fact that what Dr. Cronin engaged in was egregious behavior, there is no basis to continue to keep him on probation. Nothing has occurred in the past 10 years, let alone the past 4 years, that would suggest that he needs to remain on probation in order to protect the public. And I want to draw the panel's attention to what I cite to in my papers, which is the California Code of Regulations, Title 16, Section 1360.1 to 1360.2, which outlines some of the points of rehabilitation. And as we state in our papers, there's only one factor that cuts against Dr. Cronin, and every other factor cuts in his favor. So the first factor to be considered is the nature and gravity of the acts or professional misconduct. It is a serious misconduct. No one is denying that, least of which is Dr. Cronin, who has, throughout the past 10 years, fully acknowledged what he did. He's not denied it. He's not tried to, mitigate the significance of it. He's recognized that it was serious. He's apologized for it. He's shown tremendous insight and remorse with it, and deserves to be able to move on from it. The second factor considered in the rehabilitation is the evidence of any subsequent acts. And as I said before, the evidence in this case contains a tremendous amount of evidence of Dr. Cronin having engaged in a lot of acts since then that show rehabilitation. As I said, enrollment in treatment programs, 12-step programs, therapy, tremendous insight, remorse. The third factor to be considered here is the time that has elapsed since the commission of the act or offense. As I said, we have an isolated event that occurred with one patient between 11 and 10 plus years ago. I guess we're a little bit more than 10 years away since it stopped. So we're talking about a decade now since this occurred. That's enough time to have elapsed to show that since there's been no recurrence of any misconduct, obviously not just this kind of misconduct, but any misconduct in any way by Dr. Cronin. His treatment program monitors have all said he's been in full compliance. Even though this involved inappropriate relationship with a patient, Dr. Cronin voluntarily, as part of his program and his treatment rehabilitation, abstained entirely from alcohol. And he's been in full compliance with that for over 10 years. Again, to show his seriousness to fixing the problems that occurred and his seriousness in that he's never going to let this happen again. And that's another crucial point here is that, Dr. Cronin, beyond the efforts of rehabilitation, this was a devastating event that had major impact on his life. Dr. Cronin would never engage in anything remotely like that. He has the tools now to avoid the stressors that would cause the lapse in judgment to engage in this kind of behavior. But the punishment that he suffered over the past decade is ample evidence, and which demonstrates that, he will never do this again in order to avoid the repercussions, in addition to the tools he's learned since that time. The fourth factor is whether or not Dr. Cronin has complied with his probation, which he has completely. And then the other two factors really more apply for criminal related issues, which we don't have here. Dr. Cronin presented extensive evidence supporting terminating his probation, which is no longer necessary. The evidence overwhelmingly demonstrates that Dr. Cronin is fully rehabilitated and no longer in need of being placed on probation. He has engaged in treatment in a variety of settings, including inpatient, outpatient, one-on-one therapy, couples therapy, close monitoring, and numerous 12-step programs. It's hard to imagine something more Dr. Cronin could have done to rehabilitate himself. Continuing Dr. Cronin on probation no longer serves to protect the public and rather only serves to punish Dr. Cronin. Due to the time that has elapsed and the extensive rehabilitation, there is no potential for recurrence of the same actions. The evidence overwhelmingly supports that Dr. Cronin is a rehabilitated practitioner and no longer poses any threat to patients, whether female or male. Thank you.
Thank you very much, Mr. Jerkowitz. All right, Mr. Chambers, you also have 15 minutes for your argument, and that starts now.
Thank you, Your Honor. And I as well will be very short. There's nothing really that you're going to hear verbally from us that you can't find in the paperwork. There are no great weighty issues here as far as legal issues like you heard in the prior case. But we do have some disagreements. This was not a singular incident. This was a long-running incident that lasted a year and only terminated when the licensee was caught by the patient's husband. This wasn't a one-time mistake. Didn't run a single red light. With event after event after event over the course of a year. He accepted probation of 7 years because the people of the state of California, the people we represent, the people we answer to, need to know that they will be safe. They need to know the licensee will have a structure in place to keep them safe. So at the end of the argument we just heard, that probation would no longer serve the public or the public's interest. My office highly disagrees. The public needs to have confidence that the licensees of this board are safe to practice and will not cross those boundaries and thresholds again. It is true, this licensee has not crossed the threshold or boundaries while he's been on probation. If he had, we would have moved to revoke him. But he hasn't crossed those thresholds and boundaries because he has structure in place. He committed to a 7-year probation in order to practice in California and prove to us and to our clients, our 35 million clients, that he was safe to practice and that we could entrust him on the state or the people of the state. We still have about 2 more years of that probation. That structure needs to remain in place so that the confidence of the people of the state of California remains with this licensee and his ability to safely practice. The board has dual mandates: public safety and rehabilitation. You can find that in Business Professions Code section 2001.1. You can also note it in 2229 of the BMP code. You heard earlier in an argument that great weight has to be taken with regard to the ALJ's findings. But we set up a system with this board for redundancies and checks and balances. When a mistake's been made, as it has been in this case by the ALJ, it can be fixed by this panel. In this case, this panel can use that redundancy of systems and that checks and balances to keep the structure in place for another 2 years to protect the public under the dual mandate that has been imposed upon this board. I thank you for your time.
Thank you very much, Mr. Chambers. Mr. Jerkowitz, you have 5 minutes for a reply argument. That time starts now. Thank you, sir.
Thank you. I hope I won't take that long. Let me just clarify and respond to the issue of the singular incident. When I said singular incident, panel members, I meant in Dr. Cronin's entire career practicing, there was one lapse in his professionalism. I wasn't trying to imply or minimize the nature of that to include just one event with this patient. But when I meant singular incident, I think that is the more important factor here, rather than how many times he actually engaged in an inappropriate relationship with the same patient. The key factor is it is one patient, one egregious, one large event, but one event in an entire career where everything else is not only, consistent with the standard of care, consistent with professionalism, but is excellent, an excellent career. We heard just now that you have to protect the public. Dr. Cronin poses a danger. The ALJ's findings can be reversed, even though they have to be given great weight when the ALJ has made a mistake. Where's the substance to that? Where is the actual support for that argument? Where is there anything in the record that was presented in this case that actually shows Dr. Cronin poses a danger to the patients of California? What evidence is there that the ALJ here actually made a mistake? There is none, because Dr. Cronin doesn't pose a danger. There's nothing more he could have done in this case, and with 10 years having passed, he has shown that he is safe to practice medicine with an unrestricted license. I think one other point I want to make I didn't highlight before is Dr. Cronin has aged. He's no longer a middle-aged practitioner dealing with a lot of the stressors, and he testified to this at length in his proceeding, that he was dealing with 10 to 15 years ago when he was treating this patient. He's now at the tail end of his career. He's a wiser and older practitioner and human being. And that's another important factor in we shouldn't be judging Dr. Cronin entirely on who he was 10 plus years ago. We need to be judging Dr. Cronin today on who he is today. And with that, thank you very much. I have nothing further.
Thank you, Mr. Jerkowitz. And Mr. Chambers, you have 5 minutes as well. If you'd like to give a reply argument, that time starts now.
The argument that you just heard was that there was nothing more that respondent could have done. Well, he could complete his probation and prove to the people of California that he's safe. He hasn't completed his probation. He could do that. I noted in the filing that during his testimony, respondent brought up a statistic that he didn't have support for that we saw presented as an exhibit, but he said that 80% of people who have boundary transgressions don't do it again, but 20% do. I've cited to that page, or actually 2 pages in the testimony, it's in the filings. He's been on the straight and narrow for the course of probation. What's to keep him from being that 20% as opposed to the 80% that he cited? That's the evidence. The evidence is he's been on probation and he's kept on the straight and narrow. Once he's completed probation, he can have an unfettered license. He can practice and he can see female patients again. But until he is proven to the people of the state of California with the full completion of probation, that's the evidence. Thank you for your time.
Thank you, Mr. Chambers. Mr. Jerkowitz, would your client like the opportunity to address the board?
Yes, he would. Thank you, Your Honor.
All right, Dr. Cronin, I just want to make sure I can hear you again clearly. Can you hear me?
Yes, I can, and I have a question.
What is your question, Dr. Cronin?
I understood you to say I only have 5 minutes for this, and
No, there is no specific time limit on your statement. I limited the argument base of counsel according to the time restrictions that were given by the board in advance of the hearing, but your statement does not have a specific time limit.
thank you.
All right. First thing I'm going to have you do is raise your right hand and I'll swear you in. Do you solemnly state under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much, sir. At this time, you may address the board, please, and then after that, board members will have an opportunity to ask you questions as well as counsel if they have any for them. So you can go ahead, Dr. Cronin. Thank you.
Thank you, Your Honor. And thank you for the board for listening to my petition today. I hope to have some time here to convey some of the changes I've undergone in the past decade and reassure you I am not a danger. I appreciate what the board has had me do, and I'm passionate in pursuing ongoing recovery work, and I hope to show that ongoing probation is not necessary to have me continue all that I have been doing. I did hear Mr. Chambers say that I said that 20% of people repeat this, but that is not actually the case. I said it was 1%, and it's that 20% of psychiatrists who have had boundary violations with patients have had it with multiple patients, and 80% have had it only with one. But the recurrence of it was much lower. Anyway, I grew up with a depressed mother and a father who tried to live through me and my sister. I aimed to be perfect to please them and try to make them happy. But of course, they had their own issues that I could not resolve or repair. It made sense that I would become a psychiatrist, yet I did not fathom the deeper effects all this had had on my own development. I had grown up a frightened child in the 1960s in inner city Detroit, fearful my parents might separate and fearful on the way home from school of being attacked by other kids. I came to understand that these experiences result in an inner child in need of soothing and reassurance. Before rehab and recovery, I greatly underappreciated and even was unaware of the impact all this had on me. In fact, a general lack of self-awareness underpinned my problems at that time. Now, such issues do not run my life. They're no longer in the driver's seat nor stuffed in the trunk. They're safely secured in the back seat where I stay in conversation with them. I use this analogy with patients a lot. I share with those who help me, my sponsor, my therapist at my 12-step meetings. The shame that kind of bound me back at that time is now an acronym. And it's that the perfectionist child inside of me is trying to tell me I should have already mastered everything, which I reassure him is simply not the case. In 2002, are you still able to hear me? My screen just went dead.
We are able to hear you just fine, and I can
Okay.
see you as well,
Okay.
Dr. Cronin.
Okay,
Thank you.
I don't know what happened to my computer. In 2002, I chose to leave a large group practice I had founded to work with just my wife. I did not appreciate how much I would miss the healthy camaraderie of my fellow colleagues. I developed a low-grade depression. During the same time, my 3 children were all headed to private colleges, and my daughter developed severe medical problems, including multiple sclerosis. She also needed 3 heart surgeries. Unfortunately, I did not seek out the support of my colleagues. Instead, I became focused on a career to earn money, and 2 hours away from work to talk to colleagues was too costly. The following years have taught me just the opposite. There is always a way out. There are always means to do the right thing, a way to do something better, something more appropriate, something more helpful. My own greed, stinginess, and inflexibility stood in my way. Instead, I treated myself by shopping and buying things. In 2010, this escalated into having an office building and several homes. I found myself digging myself deeper and deeper into a problem, and I lacked the wisdom to accept that there could be help. Reach out, but think outside the box that I had made for myself. I felt more like I was a human doing and a human having than any kind of human being. I felt my life was over, and my last hope and dream was to eventually find a way to move to Santa Cruz, California. My wife said, let's do it, but I could not imagine how. Meanwhile, at that time, my parents were getting old and developing serious illnesses. In 2010, they moved across the country to my town, and in a few months, my father died. This left a very difficult situation, and likewise, my wife's parents' health had deteriorated. All 4 of our parents declined and died over a 6-year period, and we were the primary caretakers. I did not understand my own vulnerability to stress, which frankly was off the charts. Now I treat stress as a barometer, a red light that warns me to address things, bring it up, talk it out, diminish the power of whatever is affecting me, and reassure the panicked child within. Everything works out much better than I could have ever hoped or imagined nowadays. In 2011, however, I began crossing boundaries with a patient who I had been seeing since 2008. I found her charming and eager to listen. Marilyn Peterson, in her book on professional boundaries, calls this a classic abdication of the physician role, a role reversal, a boundary violation, letting the patient become the practitioner. Eventually, by 2013, this led to my most egregious boundary violation. I became romantically involved at a highly emotional level. This led to a lot of conflict in me. I began having heart problems myself, needing an operation to reverse it in 2013. This highly inappropriate situation has its reasons, but there are no excuses. I now appreciate a simple consultation could have cleared up my distortions of transference and countertransference. But back then I told myself I was too busy and it was too expensive to seek help. I have now come to see that somehow the universe, a higher power, whatever, somehow manages to take care of all the money problems I used to worry about. My career collapsed in 2014 when, as Mr. Jerkowitz said, her husband discovered this and reported it to the medical board. I was mortified when I came to my senses. I was honestly in terror and I was actually suicidal. I immediately saw my priest at church. He helped me realize how clearly inappropriate all my thinking was. I can tell you, I knew at that point that I was incapable of ever repeating what I had done. I found the results of my behavior abhorrent, and I feared I would go to hell. I was actually in hell at that point. Fortunately, in 2015, I was referred to some excellent programs designed to help troubled professionals with exactly such problems. I had no idea such things even existed. These programs proved to be very challenging and very rewarding. Of course, I did not change overnight. Recovery proved a substantial mental, spiritual, and geographical ordeal for me. I remember arriving at rehab and denying any history of trauma. I had no genuine sense of it. In retrospect, it seems very odd to me, but I actually idealized my own life. But with listening to others' stories, I discovered by discharge time that I had a list of close to 100 traumas of my own, both big and small. I got to know and understand my imperfect self. More importantly, to love and accept myself. I learned I am only as sick as my secrets. I practiced being open, honest, and direct in my communication with others. I distinctly recall an evening at rehab while reading The Wounded Healer, how I came to fully appreciate both the reality and gravity of what I had done. I became nauseated that evening with the disgust over my behavior. I was taught a great deal about healthy boundaries from 2 professional courses and several books. To stop playing a nonstop psychiatrist, to stop judging others and myself, to not be intrusive, and to always remember my role and my vulnerabilities. Over the following 2 years, my wife and I did marriage intensives, which helped us understand each other more deeply and helped me understand that my number one role in a marriage is to protect my wife's heart. Sadly, I had clearly failed. The simple idea to protect another's heart rewrote my mixed up ideas on the nature of marriage and family. With the help of 2 sponsors, one a Methodist minister and one a retired district attorney, I worked 2 separate 12-step programs and completed work on my character defects, developing a list of what I call my character antidotes. Humility being number 1. Only by accepting that I am no better and no worse than any other human being are these shortcomings able to be removed. It has worked. I was so grateful for these programs that I started 2 12-step groups in 2015 and 16. I have attended over 1,500 meetings this past 10 years. I have also sponsored several men and developed a 14-week 12-step study class in 2019, which has been repeated each year since. The writings of Bill W. of AA and his 12 and 12 hold profound insights for me. Enthusiasm, even if feigned, is positive, as is admiration of others and cheerfulness, generosity and acceptance. These things had not come naturally to me since childhood. I'm very grateful to have been granted my license in 2019. Eventually, Medicare and Medi-Cal were able to work with me. And I've also been greatly humbled to find that no organization wants to hire a psychiatrist who is on probation, nor did insurance companies want to contract with me. Furthermore, the VA and the correctional system are unable to work with me. I had applied with each. They wanted to hire me, but could not. They all told me, please come back when you are off probation. Eventually, at the suggestion of my therapist, I called a local physician who I found willing to let me work alongside him. As it turns out, I've been able to build a practice focused on addiction and bipolar disorder. This first physician decided to retire in 2022, however, and I had to search for another physician who was willing to let me work with him. The man I work with now is in recovery himself and works with addicts. A local rehab facility has referred me many patients, and I find I have a lot to offer people engaged in recovery from addictions. Sharing my own experience in a thoughtful, measured way is a moment of vulnerability where I see trust and confidence blossom between us, and real gains can be made with a patient. It has been pointed out to me that when I was diagnosed in 2021 with prostate cancer, that there was a positive result people saw. Despite the frustrations of receiving 6 different treatment opinions from 6 different physicians, I did not falter. Instead, while out surfing, I had made a friend who happens to be a radiation oncologist. He was the one who guided me to the best treatment, and it was not the one of the 6 treatments that had been recommended. I had only learned to surf because this recovery process afforded me the time. I've also found blessings in my older son taking a job nearby in San Francisco. I have pursued and made well thought out and heartfelt amends with each of my kids. I'm excited that my other son is finishing medical school and wants to do a psychiatric residency in the Bay Area next year. He wants to work with addictions. And my daughter, who has become a psychiatric nurse practitioner, took a job in our town last year and now works with my wife. She and I go surfing at dawn and see each other often. My amends to her were the most difficult I did, and I have had the deepest benefit from them. She had been very angry with me. I'm happy to tell you, my wife and I, as she says, are doing better than ever. This may sound cliched, but I really would not have made it this far without her love and support. A great deal of work has been put into our relationship, and even in the face of any future downturns or unforeseen adversity, I now have an extensive array of resources, principles, professionals, friends, and colleagues to reach out to when I'm bewildered. So I hope I have conveyed some of the changes I've undergone this past decade and given reassurance that I am not a danger and that I will pursue ongoing recovery work. Probation enforcement is not necessary to have me do this. Thank you.
Thank you, Dr. Cronin. I'm now going to turn to the board members to see if they have any questions, either for you, Dr. Cronin, or either of the attorneys. Dr. Bolat, do you have any questions for any of the parties?
Yes, I have a question, if I may, to Dr. Cronin.
Yes.
Okay. Thank you, Dr. Cronin, for providing your review of what had occurred and what you've learned over time. And just going back to the times when we are in different phases of our career, early career, mid-career, late career here, what now would we say to the people of California of why specifically you feel that you can be off of probation early?
Well, I think Dr. Sucher, who was the first person who monitored me from 2015 to 20 until he retired, said that I did more than anybody had ever done in his experience of working with people on monitoring. And I am repulsed by what I did and would never let myself get to a point where I was back in 2013. I would catch myself much quicker, and it took me years to actually totally fall down the slope. And I catch myself quickly all the time now, and I have all the resources I need, and I keep seeking out more to prevent any kind of behavior like that. I don't even flirt with people now. I often go out with my friends from 12-step meetings to lunch or dinner and notice how they flirt with waitresses, and it actually offends me, and I tell them that. And I just see no reason to even flirt outside my marriage, let alone be unfaithful outside of it.
Thank you, Dr. Cronin.
Thank you, Dr. Bolat. Let me turn to Dr. Heltzer. Do you have any questions?
No questions. Thank you, Your Honor.
Thank you. How about you, Dr. Tsai? Anything from you?
No questions.
Thank you. Ms. Torres, any questions?
None for me.
Ms. Jung, any questions from you?
No questions. Thank you.
All right. Thank you so much. Any other board members, I think, with a question for anyone? I don't see any. Thank you so much, both counsel and Dr. Cronin, for your presentations. That concludes the oral arguments in this matter. The record is closed. Case is submitted for decision, and we are off the record in this matter. The panel will be deliberating in a closed session. Madam Court Reporter, do you have any questions before you depart?
No, I do not.
Thank you very much.
Thank you very much. Thank you.
All right. And then I'll turn it over to you, Dr. Bolat, in terms of how you wish to proceed.
Thank you. It was a little garbled. Yes, we shall proceed then into closed session.